Everybody wants to get their spouse out of the house. Apologies to Dr. Seuss. There are various ways you do it, but each court in New York has its own guidelines. You can go to family court and get an order of protection. In order to do that, you have to show that someone has committed what's called a family offense. It's different sections of the penal law which are crimes or offenses, and if you've done it, the court can remove you. That's a stay-away order of protection. The court can also issue a refrain order, which basically just says, be a good person. Don't do anything wrong. It really doesn't solve any problems. It leaves the people together, and unfortunately, frequently dials up the heat. So as a rule, we suggest talking to an attorney first, making sure that you have the ammunition to get the order that you want, or that you present the ammunition that you have properly so that you can get your spouse out. In Supreme Court, they can grant you exclusive use and occupancy. You have to show you're a danger to person or property. A different set of rules, a different set of guidelines, much slower, but maybe if family court doesn't have the answer for you, Supreme Court does. Again, they can issue orders of protection too, but locally they seem not to want to do that and to leave that for the family court. Criminal court, if your spouse gets arrested, can also issue orders of protection, but in that case it's not you and your lawyer as the advocate, but it's the district attorney who advocates for you and a criminal judge who will decide whether you get that order or whether you don't. Each way you can get your spouse out of the house, different guidelines, different standards, different facts. You should consult with an attorney and get the answer as to where you should go and what you should present to get the result you want. Keith Shapiro and Ford, making our voice heard so your voice is heard.